On November 21, the union government had notified the implementation of 4 new labor codes, setting off huge protest across the country. From trade unions to bank employees to farmers, many are joining this agitation and have termed the labor codes as a deceptive fraud. The union government calls it a reform, saying the new framework will modernize outdated laws, improve efficiency, and expand social protection for workers. But the unions fear that the labor codes will weaken the existing safeguards and make it easier for employers while reducing job security and bargaining power for laborers. In this week's In Public Interest, I'm joined by Karumaliyan, who is the National Secretary for Center of Indian Trade Unions, CITU, on why the unions are opposing these labor codes. We here at the News Minute have been consistently reporting on labor issues, from mass layoffs in the IT industry to ASHA workers' protest in Kerala or to the sanitation workers' protest in Chennai. The News Minute has been on ground reporting on these stories because we believe that these stories are not just job disputes. They affect livelihoods and the dignity of people, and that is why reporting on these stories is really important. If you like our work, if you value our work, contribute to our reporting fund by scanning this QR code and strengthen our journalism. Sir, thank you so much for talking to us. What are the main objections of the CITU in terms of these 4 labor codes that have been notified by the union government?
Thank you. That it is, as far as not only CITU is concerned, generally all central trade union, except BMS, even BMS also they got some reservation on 2 code. They too agreed only on another 2 code. So more or less, by and large, all Indian central trade union against this so-called reform. Reform does not mean that they are claiming that we are reducing, that is Indian labor law is so anarchic, more complicated. We are simplifying to 4. That theory is wrong. India has got so much of labor law comparing with relatively with other countries. Why? Because India is endowed with such a natural resources where we were one way or other supposed to engage working men and women across all segments. India is a country where we got a salt pan. India is a country where we got a deep sea fishing and a deep sea all our shipping and everything. We got a mountain, we got a plantation, we got a mines, we got a BD, we got a cigar, we got a cottage industries, we got a textile. So each and every sector has got its own specificity. You cannot fix a safety measure for a worker working at the plantation at the hills and those who are working at the plain. So altogether it is a different. So our yesterday's lawmakers are their wisdom brought this law. Simply saying it is overburdened. That is wrong. I personally argued this case in the standing committee with our honorable chairman of the standing committee of the labor when we are discussing in the pre-legislative exercise. So it is logically wrong, number 1. If a reform means any labor reform supposed to bring in, naturally we have to expect that. What we will expect? A massive non-permanency is going on across the country. Every day workers are dying, yawning, longing for their permanency, for a minimum wage, or for a decent social security, and for their terminal benefits. That is the aspiration. That is the you can refer any worker, any law, any reform we is supposed to bring in should address this concern of the worker. Whether could we see so? That is why it is not for the worker. It is only for the cause of ease of doing business to abridge the legal framework to the current neoliberal ecosystem they brought in, nothing more.
Okay, just to simplify these four labor codes, why are unions objecting it? For the benefit of our viewers, what do you think are the most controversial, portions of these four labor codes that undermine, the workers' right?
Yes, definitely. It is a very good question. I can say, take an example, code on wages. If a code on wages, that is not a code, it is an act. You can say as an act. It is as IPC, like this. They codified all provision, that's all. So code on wages, wage has to be defined. The payment of wage has to be ensured. Any delayed payment of wage has to be punished. There must be a yardstick, a legal, any framework, a formula to fix the wages. I think that is a basic area where any labor law connected to wage should address. Can we now I compare with code on wages. Wage not properly defined. Earlier, the wage definition of all these laws, 29 laws, more exhaustive. It is they are saying a different wage definition. We are reducing the definition we are minimizing the definition of the wage. It is a humbug. Now, we are having a truncated, uniformed wage definition. Wage definition, it will have a repercussion from workman compensation to even ordinary social security measure. Everywhere, it will make a havoc in the entire labor law system itself. Now you see, okay, they didn't define. They are having a truncated definition. Number two, at least the law should ensure the minimum wage. Everybody supposed to expect. I don't want to get into the debate of the minimum wage in the pre-independence day or after independence. Living wage, like this fair wage and minimum wage, all these things. Straight away I am telling, law is supposed to ensure the minimum wage. But this law won't guarantee minimum wage. Now you see, minimum wage is a subsistence wage. Minimum is the bottom wage. Below then you cannot imagine. Our Supreme Court already opined that those who were not able to pay the minimum wage, please shut down the enterprise or establishment. If you are able enough to pay the minimum wage, you run the business. Minimum logic of running a business, that was a decision and pronounced from the Apex Court of India. Now they brought the floor level minimum wage. You cannot imagine what is the rate of floor level minimum wage. In 1917, they appointed one committee. 2019, they brought one amendment where from 176 they increased to 178. That was the centrally last revised floor level minimum wage. You compare in Tamil Nadu floor level minimum wage. I used to tell it is really not only bottom wage. It is going down. Now they brought in the legal framework. Earlier it used to be an executive order. The concept of the floor level wage was discussed when our experts were discussing about the unorganized committee, where they brought some judges in also, in which it was floated. But the industrial work, even for a non-agricultural operation or agricultural operation, it is more detrimental. Now they brought this into the ambit of the law. How it affected, I can say. Whether it's a concept will not affect. Yes, Andhra Pradesh notified in the draft rules that they are not speaking on minimum wage. They are speaking only on floor level wage. Now state government are going to bring down the minimum wage. They are going to have a floor level wage instead of minimum wage for a subsistence of worker who are producing the wealth of the nation. So, It is a defective. Go to in the code on wages amalgamated the payment of wage as well as bonus act. How bonus we can decide? Bonus, there is already ceiling is there. Nothing is the code on wages. Eliminate any ceiling, any threshold. I will come to the point of threshold later. At least we should know the operational results of the company or enterprise. Then only we can calculate the allocable surplus for the bonus. But whereas here it is not a mandatory to give a profit and loss account to the trade union. If we demand with the authorities, if authority direct, if they wishes employer, they can share the operational results. Then only you can demand. So all these things are the very operative part. Because I'm saying the one incident. Really, then you go to any other industrial code, I can say, cited different. You see, for an example, earlier, one provision was there. If you want to close, if you want to retrench, if you likewise, there, if an enterprise employing 100 worker, they have to seek the permission from the government. Because it is a safety valve to make a deterrent effect on any indiscriminate closure like this. Now it has increased to 300 employees. In all survey of industry, average 2 lakh factories in India. The enterprises which is factory engaging 300 worker is very minimum, very less. Maximum less than 300. So, if any factory owner, if they decide, they can hire, they can fire, they can open, they can close. So, such a opening, that now it has opened all the labor codes. That is why I'm saying 2 examples in order to illustrate my point, how it will affect code on wages. That is a crux where it is. Then after we made a very, very hectic effort and everything, with the help of INTUC, we were able to include the criteria in the draft rules. The criteria for minimum wage means how minimum wage can be fixed. Then the consumption pattern, then expenditure pattern. How we can calculate. 1957, the 50th Indian Labor Conference formulated, they recommended some formula. It is called Acquired formula. 1992, Supreme Court, in the Rappada judgment, Supreme Court recommended some formula. Put together, construct the formula for minimum wage. After our hectic fight, all central trade unions, with the help of ILO, we had our meeting. Then we went to the labor ministry. Finally, they agreed to take that formula in the subordinate legislation, draft rules. How they will notify, I don't know. It is not in the body of the act itself. If any dispute comes, the original act, the parental act will provide, and not draft rules will. So, still the quantum of the wage, everything at a stake now.
Okay, so the unions have taken a very, very strong stand as far as the implementation of labor codes are concerned. The unions have termed this as a deceptive fraud. Such a strong use of language for a reform. Don't you think it's a conflict? Because all these laws that we have, these laws have to be updated. They're old laws. Some laws have become redundant. There are many laws which actually creates confusion. So that is one of the reasons why we need some kind of understanding, some kind of clarity on what exactly we require as of now.
Yes, definitely Indian labor law, we need some reform, the positive reform. As I told, in the 1940 Minimum Wage Act, there is no definition for a minimum wage. The government can appoint, appropriate government can appoint an appropriate authority. Appropriate government can appoint one committee. The committee will, and there is no mandate or a guideline for the committee to fix the minimum wage. They may, according to the wisdom, they may recommend something. So it is called a committee system that for a scheduled employment. So definitely, it need improvement. Likewise, I can say there is so much of threshold. So much of threshold is there to exclude the worker out of the purview of the law. Now these people are claiming that it is more inclusive. We ought to eliminate all threshold. For a bonus, both for calculation as well as a quantum threshold is there. Eliminate that. We are demanding since long. PF, ESI, both establishment threshold is there. As well as ceiling is a statutory ceiling is there. 15,000, a PF 15,000, those who are getting 15,000, then they cannot be the subscriber to the PF. The 15,001, if any worker is receiving as a salary or wage emolument as a 15,001, they were excluded from the PF, ambit of the PF law. So it has to be revised. Likewise, there is so many. Similarly, now these people are saying the applicability of the law. If any worker they are getting so much of money, they will not come under the ID Act. They will not come under so many acts. The wage threshold also already is there. All this has to be eliminated. So naturally, Indian labor law needs some constructive reform. But instead of doing this, now government aligned with the new ecosystem, the neoliberalism, in the name of ease of doing business. They're saying it is a compliance burden. Can you imagine? They're saying it is a compliance burden. That is why we are going for. Sovereign parliament is enacting the law. This ministry is supposed to ensure the compliance of the law. But now my ministry, our labor ministry, now which proclaimed through the national policy on labor employment, that we are going to reposition the role of the labor ministry not as a labor-centric. We're going to reposition their role as the employment generator. It is a different role. It is a different sphere where government will do something and the employment generation. A labor ministry is supposed to ensure the 45 labor laws. Now as they get away with get rid of all this law, now they are repositioning. So reform not necessary. We have to ensure the compliance. We have to strengthen the inspection mechanism. I am saying all this according to even ILO standard, ILO convention and recommendation. Globally, it is accepted. Even European countries, they are following in some capitalist countries. So it is in capitalist countries, they are following so much of collective bargaining arrangements and union recognizing the union. All these things, we need a perspective reform in the labor law. But it is that against all these proposals, what I propose to you.
So the 4 labor codes brings down the collective bargaining strength of the laborers?
Yes, definitely. It is aimed at, the code is aimed at to ensure like a free trade zone, free trade union workplaces across all segments. That is their aim. Because any law supposed to claim as a labor law, it has to facilitate, it has to encourage worker to form a union. Workers should work very peacefully. Either individually or collectively, there must be an avenue or provision to ventilate their grievances. Now, forming the union itself became a problem. There are so many yardsticks already they brought in. Earlier, if a 7-member, you can form a union. Now it is not so. That is a 10% of a total number of any given industry. By 7, whichever is higher. All these things are there. So now already they put a conditionality to have a minimum strength in the is given industry to form a union in that segment. Number 2, under registration. Registrar, as per the code, what an enormous power. There is no deadline to give, timeline to give the registration certificate. He can prolong it. And now another danger, if any existing union does not comply with the new provision, a registrar of trade union empowered to deregister that union at a single stroke, he can do that. It is going to happen. So all these things, it will have you cannot imagine how it will, it is going to affect the worker.
Okay, at the state level, what exactly is expected to happen? Because these are all centralized codes. There are many states in India where like take for example Kerala. Do you think these labor law codes will be implemented there in Kerala? Don't you think there will be some kind of friction?
We cannot centric, Kerala centric. I can change this question as a standard and state. Okay. Labor, yeah, labor is in our constitutional scheming. It is in the concurrent list. Labor, the subject labor is in the concurrent list. Both central government empowered, state government also empowered to enact legislation concerning the labor subject. Okay, so now any labor law that was passed by the parliament, automatically it will not bind any states. So Kerala definitely will take a positive position along with the Indian working class, where to what extent we are having reservation, they are bound to align with us. Already Labour Minister Sivankutti, my friend, our comrade, he already announced that we are going to take a position in consonance with the trade union. Likewise, you will not go against the aspiration of, and opposition of entire trade union. But the thing is that, except the Indian left, I can say the present ruling dispensation has got a consensus among the all political formulations in India, from either right or centric or regional, all these forces put together, they supported this. That is why they now encouraged to notify the implementation. Mamata, for a different region, she is also opposing. But a political opposition, we are the only force left by section, provision by provision. We opposed and we have given alternative decision also. In such a way, no political force in the country which took such a position. So, they are now implementing. Now, Naidu started to implement. Karnataka started to implement. For an example, lengthening the working hour. Already, all state government, Uttar Pradesh, they suspended some act. Rajasthan already they implemented during the Corona time itself. All BJP government, they started to implement before the law-making code getting passed in the parliament. During the Corona itself, they started to implement. They suspended some law. Rest of the state government, for an example, for lengthening working hour, Supplement Establishment Act suspended in Telangana. The working related to the provision working hour. Congress government in Karnataka already they started to implement, and Andhra Pradesh they did so. So they were in now. Employer encouraged all this political dispensation except Indian left, and they were in the same wavelength to implement. But here, the rights of the state, all rights of the state on this subject of labor, now they are getting eroded. I can cite so many examples. But on Factories Act, there was no central government implementation. It was a prerogative of the appropriate government, where they got a full right. Our district collector were empowered to visit a factory. As per the Factories Act, a concerned district magistrate or collector, they were a factory inspector. Factory Act designated so, not as a law enforcement authority or authority chief of a district. As a labor inspector, he can go. Factory inspector, he can go if any accident occur. He can. Now the power of the district magistrate eliminated. So likewise, I can cite our government. Tamil Nadu is a state where I could easily say a labor judiciary at the district level. District labor court is there. Any worker can easily, after any failure report, in the conciliating mechanism, they can approach the labor court. Abolished across the country, labor court abolished. One tribunal. You know the what are the tribunal in the era of Modi. So it is not it's a state government power already reduced in the entire codification. Number two, state were getting aligned with this prescription of labor law codification, except left. That is very unfortunate. That is why now we are all across all political spectrum, trade union now coupled together in a single platform. We are trying our level best to make some impact, to change something.
Right, sir. Thank you so much for talking to us. This is a vast subject. I think whenever you come down to Chennai, we will sit together and we'll discuss more about it. Thank you so much for joining us, sir.
Thank you.